which is case 19CA0065M. Have you changed positions here? Mr. Tabak, you are the appellant. Give me a minute to clear my clock. All right. You have 15 minutes in which to present your argument. You can reserve up to 5 minutes for rebuttal. When you begin your argument, let me know if you wish to reserve time, and if so, how much. Again, these arguments are being visually and audibly recorded to be posted online, and we have read your briefs on this case, and we're ready to begin when you are.
May it please the court, I would like to reserve 5 minutes of rebuttal.
All right.
I am aware that the court is familiar with the facts of the case, so let me proceed to some issues which I think need some elaboration. I would like to begin with the libel claim that we brought, which was dismissed on summary judgment. Why a libel claim is right in this case. There was a used boat sold in 2013. The buyer, the appellee in this case, resold the boat at a profit. 4 years later, this is a used boat we're talking about. I mean, think used car, okay? The buyer, the appellee in this case, who was not a merchant, made no representation, made no warranty whatsoever about the quality of the boat, had no legal obligation to stand behind the quality of the boat, made a profit. And 4 years later, he sues. No damages. So we felt that with the elapse of time, given the quality of a used boat being sold and a claim raised in that respect, that there was something terribly wrong with the claim made by the appellee in this case. Consequently, we added a claim for libel. Let me go to the court's analysis about what was true and what was not true. First of all, allegations of wrongdoing, which appeared in the amended complaint, can be libelous if false. The only true statement established in this case to date is that there was a copy of that complaint filed in a newspaper where Mr. Husa did business. The truth of the allegations in that complaint were not established. That was up to a trial to do. So we disagree strongly with the court's characterization of what was true and what was false.
Can I ask a question there?
Absolutely.
I want to make sure I'm understanding this right. Was the publication just a standard notice that is used in every case where publication is used for service? Or are you saying there was a separate article highlighting this transaction where the complaint was posted, as we see sometimes, where there's an attachment to the article where the entire complaint can be read? Which of the two scenarios apply to you?
I'm sorry, Your Honor. The entire amended complaint with its allegations of fraud, negligence, and misconduct was published in a newspaper of general circulation where Mr. Husa did business and resided. Without any.
But was that as part of an attempt to serve him through the newspaper, service by publication? Is that all this was?
Well, not exactly, because there was absolutely no authority to serve Mr. Husa in
a different.
No,
yeah, I understand that argument.
I'm sorry, Your Honor.
I understand that argument. You're saying that it's the wrong county to publish in.
And there's a further aspect to that argument. They had no authority whatsoever to publish because they could have served him, which they were unable to do despite their many attempts to do so. Publication was not authorized whatsoever in any respect.
Was his business or his residence in the county where publication was attempted?
Both. And this suit was brought in Medina, over 100 miles away from where Mr. Husa did business and resided. The publication did not belong in the counties in a general circulation newspaper where he resided and where he worked.
Thank you.
And let me move to damages for libel. They're per se damages. They're presumed. So I'm not going to spend much time with those. I should mention parenthetically that this case came up on a motion for summary judgment. The appellee introduced no evidence whatsoever disputing the damages that were put in by affidavit by Mr. Husa and otherwise. I should mention also that the appellee tried to ambush us with a bunch of affidavits after the hearing was conducted and after the summary judgment proceeding was completed. May I now move on to our abuse of process claim? The court relied on the fact, or seemed to suggest, that the process was not perverted to cause injury to Mr. Husa. Well, it was. They tried to serve Mr. Husa, but they couldn't. They were unable to do so. So what did they do? They went outside of the county where the proceedings were taking place and published a renegade notice in a newspaper of general circulation, which had absolutely nothing to do with the Medina proceeding. That is a perversion of the process. And to add to that, the appellee knew that if he was going to publish, which he couldn't, he had to publish in Medina. So what do? They go to Lake County and Ashtabula County to publish. That's important to our claim that they did this with the ulterior motive of harming Mr. Husa in his trade, business, and personally. Now, why should they try
Well,
to
Mr.
harm him?
Tabak, let me ask you something.
Yes.
How would publishing in Medina be serving the purpose to give him notice, your client notice? I mean, that's the purpose of publication, correct?
Right, right.
How would publishing in Medina be serving that purpose if his home and business is 100 miles away?
Well, I think the appellee can better answer that question because they decided to bring the lawsuit in Medina. And under the Ohio Rules of Civil Procedure, publication is made in a general circulation. It's supposed to be made where the lawsuit takes place. But they had no authority to publish whatsoever anywhere in Seattle, Washington, or in Miami, Florida, because they could have properly served Mr. Husa, and they did not. They were unable to do so.
They sent the complaint by certified mail, by regular mail, and they used a process server, was my understanding. None of which was successful.
None of it was successful. That's correct.
Are you saying if they would have published in Medina County, that would have been good service?
No, they were not entitled to publish because they could have served him at his residence. That would have kept everything under the radar. That's the purpose of residence service, to avoid publication. Publication is only extraordinary when you cannot keep the radar, the case below the radar. If they had properly—
And I'm sorry, but the only attempted service then was at his business address.
No, they sent certified mail to his residence, but they didn't properly follow up. They tried to— I'm sorry.
No, go ahead. I interrupted you. I'm sorry for interrupting you.
Yeah, I mean, basically, if you are able to properly serve, which they tried to do with residence service, then that's the way you do it. You can't publish anywhere in the United States, but they didn't do it and they couldn't do it for some reason. So they went outside the county where publication would have been authorized had service, not been available by residents, and perverted the process. That's our point.
Thank you.
May I move to damages? The underlying purpose, this bears comment, to harm Mr. Husa. Throughout their pleadings, they blame Mr. Husa for their inability to effect service on him, which brings to mind a comment of Judge Collier, which you have in the preceding case, which said, the appellee blames everyone but themselves for their failure. That's exactly what we believe happened here. They were so frustrated that they were not able to serve Mr. Husa that they wanted to harm him. and his business. That's an ulterior purpose, which we feel meets the definition of abusive process. Now, may I move to the damages? We submitted an affidavit. The language is not language I would use. It is language that Mr. Husa uses. That's who he is. I'm reminded of a case called State Ohio versus Jacobellis, which was one of the early pornography cases. This is on topic, believe it or not, where Justice Stewart said, "I know it when I see it." Well, Mr. Husa's expression of his feelings about the damage done to him, people understand exactly what he meant when he used the scatological term that he did. And this is a court, and courts are dedicated to the principle that we must speak freely, and this is who Mr. Husa is.
Mr. Tabak, you're right
Yes.
at your 5 minutes. You're welcome to keep going, but I just want to keep you apprised of your time.
I'm done.
Okay, I'll pause you so you have your rebuttal time. Mr. Owens, whenever you're ready.
He's on mute.
You should be able to hear.
There we go. I apologize. It took me a minute to get unmuted.
Okay.
Thank you. There are a number of problems with Mr. Tabak's argument. The first is that he spends a lot of time in the beginning of his argument arguing about what the complaint says. The complaint was never published in the legal ad notice. This was simply a basic legal ad notice that stated the parties. It stated the name of the court, the name of the lawsuit and case number, and the nature of the claims without any embellishment whatsoever, any facts that would support the claims, just a very simple legal ad notice. What the trial court found was that relative to libel, there was nothing in the legal ad notice that was untrue. You can't have libel without statements that are untrue. And in this case, everything stated in the legal ad notice was true, so it can't be a libel claim. Then he goes to abuse of process. There was absolutely no evidence of perversion of the use of service by publication in this case. Mr. Husa had dodged service. As Judge Teodosio pointed out, we had tried every form of service we could think of, all the way up to, as a last resort, service by publication. We even had a hearing in the trial court asking to be able to do service by publication. And the magistrate said, well, that's not something I have to order. You just go do it. If you need to do it, you go do it and publish. That's what we did. Unfortunately, it was published in the wrong county in error, which we acknowledge. That was not something done intentionally. But there's no basis here for abuse of process. The purpose for publication is to obtain service, and that was the end goal, simply to get service on the Husa party so that we could commence our action against Mr. Husa and move on with the litigation. That did not happen. He's flatly wrong to say that we could have just served him at his residence. Well, we tried. The record is replete with facts and incidences where process servers were sent to both the residence and the business address over and over again with no success. Relative to damages for libel per se, it is true that those damages are presumed, however, they are rebuttable. And in this case, there was no evidence whatsoever of any damages that Mr. Husa could have. Even if you could find that there was libel, there were no damages, and certainly for abuse of process. Mr. Husa's affidavit did not allege any specific loss of business, did not quantify any sort of loss of business, did not give example of customers that he lost, anything like that. He simply was upset. And we understand.
Isn't mental suffering, mental anguish sufficient as an element of damages?
I suppose it could be if he could establish mental suffering. If there was a basis for abuse of process, which we argue there was not, or libel, But he didn't establish that simply by saying, quote, "I feel like shit." That's all he says. And we would argue that that does not establish damages in this case. And with that, that would be my comments. Thank you.
Mr. Tabak, you go ahead.
You're on mute, Mr. Tabak.
The publication claimed fraud, negligence, poor workmanship, any kind of aspersion you can make on someone's business. Published in the newspaper where Mr. Husa resides and works. Thank you, Your Honors.
All right. Excuse me. Thank both of you for your arguments in both of these cases. We will take both matters under advisement, issue written decisions, which will be mailed to both sides, as well as posted on our website and that of the Supreme Court. We will next